Hello and welcome to Ganja Law 101, Episode 4. I'm going to go a little bit over what we talked about in the last episode. We talked about the peyote exemption in the international treaty, and I've got it on the screen right now, and I want you to pay really close attention to that wording. This is from 1971. This thing was created in the federal level in 1966, and they had decided to do it by regulation rather than statute. And so this language is based on that is where this comes from. So it says, peyote harvested and distributed for use by the Native American Church in its religious rites is accepted from the provisions of Article 7 of the Convention on Psychotropic Substances. This goes back to what I was saying about the International Narcotics Control Board saying that the United States is out of compliance with Article 4, Section C of the Single Convention, which has got the same language that this convention has in Article 7. But that is for people who harvest and distribute peyote for the church. So the exemption is for them and not specifically for the church. The church inherits the exemption through the fact that they have a legal source to get their sacrament from. Going to that treaty, you can see Article 5 says limited to medical and scientific purposes, just like the Single Convention. Section 1 here refers to Article 7. Article 7 says scientific and medical. The religious use of peyote is not scientific or medical, so these treaties could not possibly prohibit an exemption like the one there is for peyote. And specifically the way that it's written for the people supplying the product to the religious organization. So the next thing I wanted to talk about was the timeline here from the time that this single convention was created and the peyote exemption came into existence. In 1961, the Single Convention on Narcotic Drugs was created, and it had cannabis in there, but it did not have peyote. Then in 1964, the California Supreme Court found that the religious use of peyote is protected by the First Amendment to the federal Constitution. And then in 1966, the federal government created the religious exemption by regulation rather than statute because they wanted to do it as a business deal like I just showed you. They wanted to regulate the businesses that supply the sacrament to the religious organization. And that is why they did it as a federal regulation. You don't regulate somebody unless they're required to get a license and keep records. Then in 1967, Iowa created this religious exemption for peyote, and they copied the words exactly the way they're written in the federal regulation into the Iowa statute. And it says, persons who supply the product to the church must register. Well, there you go. So it's got to be some kind of a regulation, some kind of a license. Your freedom to drive is limited because you have to get a driver's license. So the freedom to use controlled substances in religious ceremonies is limited to you have to get a license. And who gets the license? It's the people who supply the product to the church. Then in 1967, the United States adopted the Single Convention, and by that time they had already established this peyote exemption. Then the Federal Controlled Substances Act was created in 1970, and there was this federal regulation exempting peyote distributors. Then the Uniform Controlled Substances Act was created in 1970 for the states to follow. and they recommended an exemption for peyote. And then the Convention on Psychotropic Substances was signed and created and signed in 1971, and that actually has this exemption for peyote that I was showing you. And then in 1971, Iowa adopted the Uniform Act and put the exemption for peyote in there. So you can see how interwoven this peyote thing is throughout all of this, and that it's not religious or scientific use. And so for the International Narcotics Control Board to complain that the United States is not in compliance with the treaty because of marijuana, the reason for that is because the federal government does not recognize any state cannabis program as legitimate. So the United States tells the International Narcotics Control Board that none of that is authorized. And so the International Narcotics Control Board turns around and says, well, then you're out of compliance with the treaty. Well, if the United States government and the states got together and applied an exemption like the one there is for distributors of peyote, there are 5 of those in Texas, and we have 5 distributors of cannabis in Iowa. The 5 distributors in Texas are licensed by Texas and by the federal government, which makes that whole thing legal. If we got our distributors licensed here in Iowa, that would make our whole program in compliance with the international treaty for the same reason that peyote is, because it would not be scientific or medical. It would be some kind of, for a good purpose, should we say, like, religious exemptions are considered to be like for something good rather than something bad. Well, a state program that is created for people to use marijuana for medicine is certainly in that same category. So all the pieces fit. The only thing that's missing is that all of this wasn't set up as these things were being created. Marijuana comes in later. 1996 was the first year, and so it's not being done smoothly, but we need to end up in the same place that we're at with this peyote exemption. It needs to be authorized by the federal government. It can't be recognized as medical or scientific. It doesn't need to be. There's another category, and that's for a good purpose. So anyway, that goes through the history. So in 1981, the Office of Legal Counsel at the Department of Justice was asked by the DEA to explain this peyote exemption to them. And so the Office of Legal Counsel is that's the legal experts. And so the legal experts explained to the DEA that the peyote exemption is based on state Supreme Court decisions recognizing the religious use of peyote as protected by the First Amendment to the Constitution. Well, those states didn't create a regulatory program, so the federal government did by enacting this regulation, and so the purpose of the federal peyote exemption is not based on the Constitution. And if you look at it, you'll see that the exemption for the Native American Church says the listing of peyote as a controlled substance in Schedule I does not apply to the non-drug use of peyote in bona fide religious ceremonies of the Native American Church, and members of the Native American Church so using peyote are exempt from registration. So you see that they're not registered and they're not regulated. Any person who manufactures peyote for or distributes peyote to the Native American Church, however, is required to obtain registration annually and to comply with all other requirements of law. So you see that these two things are intertwined. It's a secular exemption for secular businesses to distribute peyote to a religion that thinks it's a sacrament, and they become legal because the distributor is legal. And that's how users are exempt in the federal drug law to begin with. And so if you read the federal statute that authorizes this kind of activity, it says the Attorney General may, by regulation, waive the requirement for registration of certain manufacturers, distributors, or dispensers if he finds it consistent with the public health and safety. So that's what these peyote distributors are. They're not end users. They're manufacturers, distributors, or dispensers. And the federal drug law includes a waiver for those kinds of activities, and that's how this whole thing fits together. So it's not done the way that those state Supreme Court decisions did it. It's done based on the language in the statute, in the federal drug law, the Controlled Substances Act. And then if you read Section 21 U.S.C. 822 C3, it tells you the following persons shall not be required to register and may lawfully possess any controlled substance or list one chemical under this subchapter. And then under paragraph 3, it says an ultimate user who possesses such substance for a purpose specified in Section 802.25 of this title. And that's a typo. The sections have been renumbered. It's 27 now. So on 802.27, it says, as used in the subchapter, the term ultimate user means a person who has lawfully obtained and who possesses a controlled substance for his own use or for the use of a member of his household or for an animal owned by him or by a member of his household. So you see, the end user is not registered. They inherit the legality from the source that they're obtaining it from. And that's how the peyote exemption works. You really need to pick up that detail there, because it's not just an exemption like the state of California granted through a Supreme Court case or the Arizona Supreme Court through a court case. This was a regulation that was crafted to be the specific way that it is. And the reason why that's so important is because the state cannabis programs could fit right into that exactly the same way. So moving on, I wanted to go through my history of trying to use this peyote exemption as a model for a cannabis exemption back before there were any state cannabis laws. Okay, so I was a member of the Ethiopian Zion Coptic Church, and a member of the church has written a book on this that is really detailed, and I can't describe what was going on as well as Clifton can, and his book just goes into detail, a lot of stuff that I was aware of, but just didn't know the details as well as Cliff does. So I've got some links here to his book. He has he's doing audio podcasts on Amazon, Spotify, and Apple Podcasts, and it's powerful. But I will let you explore that on your own. So in 1978, I got arrested in Iowa with 129 pounds of marijuana, and I raised a defense that I was a member of the Ethiopian Zion Coptic Church and that my activity was protected by the First Amendment. Because I didn't know the law as well as I know it now, so think of this, how I thought of it way back then. I thought it was protected by the First Amendment because I didn't know. I was like the California Supreme Court, okay? And I knew that just when I got arrested in 1978, I was aware of the 1964 California Supreme Court decision on the peyote. So that's what I based my whole argument on, that case, that California Supreme Court case called People versus Woody. So anyway, then in 1979, I had moved to Florida, and I was living at the church headquarters in Miami, and the property was owned by a person named Jacqueline Renee Town, who happens to be the wife of Clifton Middleton, so you can see that that association. In that case, the Florida Supreme... Okay, that case was they filed a zoning injunction infraction against the Jacqueline Renee Town, the owner of the property, for operating a church in a residential zone. on Miami Beach. And the Florida Supreme Court upheld the injunction against the church, against Jacqueline Renee Town. But the ruling says that in the instant case, however, we find the state's compelling interest outweighs the free exercise interest of the petitioner. To hold otherwise would, for all practical purposes, legalize the use of cannabis for anyone, member or non-member of the Ethiopian Zion Coptic Church, who came to the petitioner's residence to use the prohibited drug. And I'll just say there was no evidence in that case. Well, I went with a state attorney down to Jamaica to interview church elders in 1979, and so I'm intimately familiar with the case. There was no explanation of where the church obtained its sacrament or how it. The testimony was that the church uses marijuana all the time, everywhere, with everyone. And so that's what the court is saying here, is that if they were to find that activity protected, anyone could use marijuana because churches don't prohibit people from visiting. So you wouldn't have to be a member of the church to visit, and you would be exposed to marijuana if you had visited the church there. So then in 1981, well, I should also mention that in 1980, I got arrested again with 20 tons of marijuana in the state of Maine, and we raised the same argument that we were protected by the First Amendment, that we were members of the Ethiopian Zion Coptic Church. And so that was all going on. Court cases were going on while this decision came out from the Office of Legal Counsel that I referred to earlier. And in that explanation that the Department of Justice gave to the Drug Enforcement Administration for the purpose of the peyote exemption, it says that the purpose of the peyote exemption does not appear in the legislative history. Well, that's because it was never legislated. They decided not to legislate it. Instead of making a statute, they decided to make it a regulation. So, of course, the purpose of it doesn't appear in the legislative history because there wasn't any legislation. But anyway, then it says it appears to be based on these California Supreme Court decision and a Arizona Supreme Court decision from 1960, and those are based on the First Amendment to the Constitution. And then the Office of Legal Counsel says that the peyote exemption must have a secular purpose, because you can't have establishment of religion. You can't grant favors to religion that aren't equally available to non-religion. And then it says the exemption should not be viewed as having a religious purpose. So it has to be based on something else. Going back to 21 U.S.C. 822D says, in the interest of public health and safety. So that would be, if it's not a religious purpose, then the only other explanation is the statute, and the statute says if it's consistent with the public health and safety. So there it is. So that's why I'm making the argument about the state cannabis programs. They're in the interest of public health and safety. So it's a perfect match. So then the next thing comes along is Clifton Middleton's case, and the court ruling in that one. He was arrested in the airport with some marijuana, and he made the argument that that was activity related to the Ethiopian Zion Coptic Church. And that court, the 11th Circuit at the time, said, "We will not therefore subscribe to the dangerous doctrine that the free exercise of religion accords an unlimited freedom to violate the laws of the land relative to marijuana." So I think Cliff was coming from Jamaica, and it wasn't legal in Jamaica. It wasn't authorized for religious use. It is now. In 2015, they recognized it as a religious sacrament. But anyway, so what? Again, if you compare this to peyote, which had a valid legal source, Clifton Middleton, just like Town, just like me, didn't have any explanation of where the marijuana would come from, except we would get it somewhere, we would grow it. And they said, well, I mean, it never came up. We weren't smart enough to say we wanted a DEA registration for that, so But anyway, you would have applied for a registration before you got arrested anyway, so that would be kind of a clunky way to make that argument. And then in the case that I was talking about with the 20 tons, that ruling from the First Circuit was that no broad religious exemption from the marijuana laws is constitutionally required. Now, all of these cases just say the same thing. And then I finally got a decision from the Iowa Supreme Court, and they said, nonetheless, he asked us on this appeal to afford his religious use of marijuana unlimited constitutional protection. So you see, it's just the same thing over and over again. Unlimited, it would be just absolutely unlimited. And the peyote exemption obviously is extremely limited because the DEA registers the source of the peyote, and the church is completely bound to that supplier. That supplier is going to determine how much they get, and that's how the DEA keeps control of that, because they register the supplier. So that's the reason why all of our cases were different. And then I decided, instead of being prosecuted, I would file a civil action for a religious exemption with the DEA. And they denied that with the same argument, saying the overwhelming difference explains why an accommodation can be made for a religious organization which uses peyote in circumscribed ceremonies and not for a religion which espouses continual use of marijuana. The Native American church doesn't use peyote all the time everywhere, and so that was a difference. But that's not the biggest difference. The biggest difference is that legal supplier. Because if the Ethiopian Zion Coptic Church had a legal supplier and had a limited supply, they wouldn't be able to use it anywhere all the time everywhere. So that was the piece that was missing, and there wasn't any even arguable source of marijuana back in 1990 or 1989 when this decision was made. And now there is. Since 1996, there's been states have been authorizing the production of marijuana. And then in 1990, the whole thing ended up with a Supreme Court decision on peyote, Employment Division versus Smith, and it said that our most recent decision involving a neutral, generally applicable regulatory law that compelled activity forbidden by an individual's religion was United States versus Lee. So what that means is that a couple drug counselors were fired from their jobs for using peyote in a ceremony of the Native American church, and they applied for unemployment compensation and were denied, and the Supreme Court of the United States said, if the state of Oregon doesn't allow any exceptions to its drug law, then it's not required by the First Amendment to the United States Constitution to create one. So you see how that goes right back to the Office of Legal Counsel explanation that this is not based on the First Amendment. See that? It's just consistent. It's just a continuation of the same thing. This is a secular exemption that's called a religious exemption, but it's not. It's a secular exemption, and it's not for the religion, really. It's for the suppliers, and they're not part of the religion. So that's how it becomes a secular exemption, and it's only for businesses that supply the controlled substance to the religious organization. And that was how Oregon didn't allow that, and they didn't allow it for anybody else. So even though they had a federal exemption, the state exemption didn't exist, and they lost that case because the U.S. Supreme Court said they're not going to force the states to allow something unless they're already creating gaps in their system for other people and discriminating based on we don't like you and we do like you. I mean, just handing out favors. The state can't hand out favors. As long as they're consistently denying everyone, they can deny religious activity. So that a lot of people are really upset with that. I never made an argument based on the First Amendment. Mine was based on the First Amendment and an equal protection argument, saying you're already allowing the use of peyote, now you've got to allow me. But I didn't see so clearly that the difference between peyote and me was I didn't have a legal supply. So in that case, I made some goofy arguments. to try to make up the difference. I didn't have anywhere else to go with it. So I said, well, what if I just restrict my use of marijuana and I get it from the federal government? And they said, Olson refers to his proposal for restrictive use and claims that this case is now differently contoured than his earlier ones. This is a civil case. The other ones were criminal. Even if the government is not required to accommodate to the extent of allowing a broad religious exemption, he argues, it can and must accommodate his time and place specific use that he has proposed. Because the tenets of the Ethiopian Zion Coptic Church endorse marijuana use every day throughout the day, however, Olson's proposal for confined use would not be self-enforcing. It's hardly unreasonable to forecast a large monitoring burden in light of evidence that in years past the Church's checks on distribution of cannabis to non-believers in the faith were minimal. There was easy access to cannabis for a child who had absolutely no interest in learning the religion, and members partook of cannabis anywhere, not just within the confines of a church facility. Well, if you were limited by the source and you didn't have the ability to get an unlimited amount of cannabis, you would have to figure out when and where to use it. We couldn't do that because we didn't have anything set up like the peyote distributors in Texas to get our marijuana from. So, yeah, my argument was absurd, and they laughed me out of court. Then they said, critically, Olson's proposal would require the government to make supplies of marijuana available to Olson's church on a regular basis. Because I said they should give me marijuana from the government research facility at the Mississippi Marijuana Farm. We are unaware of any free exercise precedent for compelling government accommodation of religious practices when that accommodation requires burdensome and constant official supervision and management. So basically, the peyote distributors are not government research facilities. They're private businesses licensed to supply peyote to the Native American church. So the federal government is not going to take a research facility and start supplying cannabis. And not only that, we wouldn't have to pay for it. If the government gave it to us for free, the peyote distributors want to get paid for their peyote. So this was just such an awkward thing. I argued it because I knew they had me on the source. I didn't have a legitimate source. So this argument was simply an attempt to make one up to show how unfair the whole thing was, but they didn't cry a tear. They were just unimpressed. And so basically the end of that story was go to the legislature and get them to carve out an exemption and to create a legal source or whatever. I don't even know. Like, we got a legal source here, but we still need a federal exemption. So, but anyway, that wasn't for them to figure out. They just told me my argument wasn't very good, and I knew that. So, but I made that argument just so that you can see today how I still see those same things at play, and it hasn't changed, and that's how the whole thing works. So I'm going to wrap up this episode with that and just say that we need to apply for a federal exemption, which is what I said at the end of episode 2. And the reason I keep saying that is I've actually filed for one, but I need to explain that because there's a lot of... Anyway, that's going to be episode 5, and thanks for tuning in. Catch you next time.